going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. All right, I have got a pro se defendant who makes some interesting comments in her case. Yeah, that's the best way I can explain it because I have no idea what's going through her head. Clearly, she needs an attorney. She does, especially after she tries to do what she does. She gets called out for it. But anyways, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Appointed attorney paperwork, and I believe she'll be asking for an attorney.
How are you?
This is case numbers 23S00721SD, 22SO02227A, OI, and 23S00721, again, for bond violation hearing. So these are people of the state of Michigan versus Sheree Wilson. So it's really one case and it looks like a civil infraction.
Michelle Mitch on behalf of the people.
So what's your name?
Sheree Wilson.
All right, so Ms. Wilson, good morning. You're here for operating while intoxicated for a pre-trial, and then there's a preliminary drug test ticket that you also have is scheduled for formal hearing, and then there's a bond hearing as well. And what's that got to do with some no-shows on ECG and drug testing? So, how would you like to proceed since you don't have a lawyer?
I never got charged for bond. You brought that up before, we already.
Well, scheduled today. So my doctor.
Since I've been fighting this for a year, my lawyer drew on me, and I only had 6 weeks. I am a seasonal tax preparer, so I did need more time to try to find a new attorney, because I gave her large sums of money already. I'm gonna have to come up with more money for the attorney. But I did want to make some stating facts that I don't know if she made.
All about the case?
Yes.
Why don't you wait till you get a lawyer?
Because I believe I have a good point. for
Okay, well, what
myself.
is it you want to say?
Okay, so you watched the court video. I also have my own video. I
What are
would
you
like,
talking about, an emotion hearing?
for what?
A motion hearing, when did I watch a video?
For the OWI.
It has to be a motion hearing. Okay, so you want,
I don't feel like the officer had probable cause to search my vehicle in the first place. In the video, he stated he smelled alcohol, which is why I tested 0% for alcohol. So it's like, what was his probable cause of even searching my vehicle? Then in the video, they said I refused PBT.
okay, hold on. Do we have a hearing on this? Let me see, if this is the second ROA, let me look and see if there's a first ROA. There was a motion to suppress blood alcohol evidence due to a defective search warrant. We had a hearing on that. That was denied back on May 1st. You're talking about something different?
That's what I'm saying. I don't know what Ms. Coleman was arguing on why those points wasn't taken into consideration, but the officer had no probable cause to search my vehicle.
But we've already dealt with the issue.
But I thought now, because
Well,
since she's
there's a
gone,
search warrant. No, it doesn't work like that. You don't get to start over because she's gone.
okay,
All right. So this is what's going on. This defendant either fired her attorney or the attorney withdrew. And it sounds like it was a retained attorney because she was talking about money. Now, because the attorney's gone, she wants to redo the probable cause. probable cause conference, PCC. Yeah, I mean, it doesn't work like that. It doesn't. And that's not the only thing that she tries to pull over the court. She tries to do something else here shortly, or she says something else here that doesn't make any sense, which is why I put this video up, because I personally find it funny, and I can't believe that she actually thought it would work. All right, let's go.
This is the law of the case now. If we've already dealt with the issue, it's already dealt with. That's the ruling, so we move on.
Yes, she didn't even explain that part to me either.
Now, what you can do is talk it over with your lawyer. That lawyer could have, if they want to order the transcript, see what occurred, have the court order right here, then they can do that and review it with you and make a determination if they think there's something else they
So
need
is
to
it too
do.
late to appeal the decision? Is it too late to appeal?
You need to find out and ask your lawyer that.
Right, but I'm seasonal. And I've already given her money.
Well, I thought you were trying to hire another one, you just told me.
Yeah, but it costs.
Okay, well, were you gonna apply for a court appointed attorney if you don't have lawyer money?
I just want to try to represent myself.
Well, ma'am, you can certainly do that. It's not I wouldn't think it would be advisable, but you can certainly do that if you think you know all the ins and outs of how to best defend the case.
Okay, that's fine.
So do you want to represent yourself?
Yes.
Okay, well, then this is a pre-trial date. So today is the date to determine, they had made you an offer, I thought.
And that's not an offer. It's basically telling me to plead guilty to something that's not fair. They had no probable cause in the first.
Well, we're beyond probable cause now. Okay, so we have to decide just a simple issue.
See, that's exactly what an offer is. You plead guilty to something. Usually on offer, you're pleading guilty. They'll dismiss one of the charges, or you can plead guilty to a lesser charge. Now she's charged with an OWI, and she's saying that she blew zeros, but they were trying to suppress evidence of even having the blood draw in evidence. So this is what doesn't make sense to me. If the defendant's saying she blew zeros, but they were trying to suppress the blood alcohol evidence, maybe she had something else in her system. So this maybe not have been an alcohol DUI. Actually, that makes the most sense. I'm not exactly sure, but that makes the most sense. Yeah, anyways, let's go.
Do you want to take the offer or do you want to have a trial?
I'll go try.
Okay. What kind of trial do you want? You want to have a jury trial or you want to waive your right to a jury and have a court try the case?
Jury trial's fine.
Okay. Now, let me explain the jury trial. That is a real involved process that you can do. You certainly can do it, but you're going to have to understand how to do it.
Right.
And so you need to probably read up on the Michigan court rules, and they're available online. And there's a whole court rules about picking jury, how many jurors you can pick, how to strike jurors. This is a whole selection process there. Then you're gonna have to understand the Michigan rules of evidence, because I have to hold you to the same standard as I would a lawyer. I can't give you a break because you don't know the rules.
Right.
So, and to your advantage, you need to have somebody helping you, I would think. But if you want to do this on your own, then you need to look at the rules. There's evidence rules, and then there's just basic court rules that apply to trials in some criminal cases. So you need to pull that up online, or some people buy the book. So I'm just gonna tell you that it's not as easy as you would think it might be. If that's what you want to do, we will set it for a trial, and you don't want to have a lawyer.
And Your Honor, if I may, if the court would be inclined to set a standby counsel, Ms. Wilson has every right to represent herself. The only
What I've been
issue-
told, MIDC won't pay for those.
Okay, the only issue I foresee here is obviously the court has already stated that the motion has been ruled on, that there's no suppression of the blood results, that there was probable cause for the stop. And my concern is that during the trial, that will come up when it should not be coming up.
Well, you can file your motion in limine,
Okay,
and I'll make the ruling, but the ruling is gonna be that it should not be coming up, because it's already been decided, so you can't argue that to the jury. That is an issue of law, not fact. And facts are what the jury decides. Law is what the court rules on. So you can't bring that up. But if she wants to file a formal motion on that, it's just perfunctory, but at least it's in the record properly. Okay, so jury trial date.
Court's available October 8th.
Hey, October 8th, 8:30. Jury trial. As to your bonds, I have 2 no-shows, same date for drug and alcohol test, August 11th and July 27th.
You've already brought that up and we've already discussed it. I'm confused.
Well, let's see. You
And
couldn't
then
have,
and
because the
you
last,
changed me to from,
the last
4 times
time,
a week to twice a month. And
the
that was
last
brought up before.
time we did that was May 1st. Where I changed,
I haven't missed anything since.
okay.
And you've even changed it, so.
This is the report from pretrial services says that you did in August and July. We changed that way back in May 1st.
I've been testing twice a month, I've never missed.
Okay.
I'm so confused.
Well, all right, that's why we have hearings on these things. You want a hearing?
Yes.
You want to? Or the testing agency that she goes to is ATS. Says defendant failed to attend random testing at ATS on July 27th and August 11th. Then the defendant self-reported on July 30th and August 12th. So she missed it and then turned herself to go back in on her own.
I have a day to make up if I miss one
It
day.
doesn't work like that. You don't make up.
That's what they said, and I paid $40 to do a makeup, and I have 24 hours to make up. So I'm so confused.
Yeah, so are we. Now, I can't imagine this being factual. I can't imagine this being a real thing. You may have to pay a fee for a makeup if you miss, but it's still a violation. You can't just pay money. Spoiler: the judge is about to say this exact same thing. So essentially, she's missing a test. She's paying $40 to make it up the next day, or maybe 2 or 3 days later. Who knows? But could you imagine? Like, oh, I drank last night. I'm going to test positive. Well, it looks like that's going to cost me $40. I'll go test in 3 days when it's out of my system. Yeah, no, you can't do that. Everyone would do that. Well, not everyone. People that had $40 to throw away. Yeah, no, it doesn't work like that. Sorry, lady. Next.
And I can subpoena a representative from ATS to be here for a hearing, and we can go through all of that. I'm not sure what they would have told her.
I have no idea because it doesn't work like that. If you miss a
So
drug,
what's the point of paying the 40 if you pay 50?
well, I don't know what they told you, but I can tell you this. If that were the case, people would just skip every time and make it up. And then they would have drank something and we wouldn't have known about it. And then they go later and make it up within a time frame where it can't be detected. It don't work like that. You have to go on the date that you're supposed to
So
go.
what is the point of them accepting the $40 payment if you miss?
I
They
don't
give
know.
you 24 hours to make it.
I don't know why they did, but certainly at a hearing, you can bring all that out. As to they told you that.
Okay.
That's not how it works here. I don't know why they told you that, but you can surely cross-examine them and question them. So if you want to set a hearing on that, we will, and we'll do it before this, trial then. Bond hearing, date, please.
Yeah, so I've been thinking about it since I made my last comment. The only thing that would make sense is you have to pay some kind of fee for missing your test and rescheduling. So like a rescheduling fee for them to put you on a day you're not supposed to be there to remake it to make it up. That's the only thing I can think of. So maybe that's $40. But yeah, that doesn't excuse the fact that you didn't test that day. You don't get out of it. It's still a violation. You're still in trouble. And like I said, she just admitted to missing it. So I don't know why she's going through with this hearing for someone from the agency to explain to her what that fee is, even if there is a fee. I think it would be hilarious if someone from the agency comes in and it's like, oh, I just collect $40 from them when they paid me for it. Yeah, that's not going to happen.
Thank you.
Bond hearing date will be what?
Court's available September 27th at
Or anything before that?
court's docket is full.
All right, well, that gets asked for September 27th. At what time?
Make it September 23rd at
That's good.
9 a.m.
September 23rd at 9 a.m. Prosecution will subpoena the witnesses that they believe they need for this bond hearing. And right now, your bond is continued. So give her a notice for the bond hearing too. She's on set.
I believe she gave.
Okay.
All right. This video is pretty much over. I should have just cut it now because all they're doing is scheduling. Thank you all so much for watching it. I appreciate it. If you haven't hit that like button already, please hit that like button. It helps more than you know. All right. You guys have a great day. Until next time. Bye.
That's the court.
And Ms. Wilson, if you decide you want, get home, you change your mind, you decide you would like an assigned attorney, you gotta let us know well in advance of this October trial date. I'd say within the next 7 days. You'd have to come back in and fill out a form for that, okay? This case number 24.